Thank you for joining us for another episode of Disrupting Divorce. And as many of my loyal followers and listeners know, I'm always looking for interesting new topics that we can be talking about on the podcast. And so I want to welcome Brett Ward. Thank you for joining me today.
Thank you for having me.
So, Brett is actually the co-chair and litigation expert at a firm that's based out of New York, but has offices, I'm learning, all over the country, blank Rome. And so, thank you so much for joining us. I know our topic today is going to be, if nothing else, an interesting one. So, let's dive into it. So, the reason that I originally reached out was because you were quoted in a People magazine article that I thought might be an interesting topic. So, that's what's on the docket for today. So, you're going to definitely want to make sure that you stick around for that. But before we dive into it, can you share with us what you, on behalf of your firm, are doing to disrupt divorce? And for those of you who are new to the podcast, my definition of disruptive is doesn't mean that we're going in and ticking people off necessarily. What it means is we're looking for ways to do things better, thinking outside the box, really making sure that we are bringing the best possible solutions to our clients. And so that's really the definition of disruption.
First of all, thank you for having me on the podcast, and certainly thank you for asking me this very important question. What I would say that I'm doing to disrupt divorce, and as you mentioned, that I co-head the litigation department at Blank Rome, and I was formerly the head of the family law section. And I think one of the reasons for that and the way I disrupt divorce is I treat it like a real litigation. Okay. And that's, I have my clients, they settle early and we can be a part of mediation. And I really encourage people to find alternative dispute resolutions. But when those interventions can't happen, you have to take the case very seriously. And when I present the people at my firm to potential clients, I don't say that we're matrimonial lawyers. We are litigators who practice in the matrimonial family law field. And there's a difference because there is this aspect of divorce which clients feel happens to them, and that the process just kind of sweeps them up and takes them along, and the attorneys go in the back chambers with the judge and they talk about them, and the clients sometimes never hear it. And even when they do hear what's going on in court, much of it is in legalese and they don't understand it. And then at some point, the lawyer comes to them after charging them a lot of money and says, now it's time to settle. You can't fight. All right. There's not involved in the strategy from day one. There maybe isn't a strategy from day one other than just to file the documents that are supposed to be filed and exchange documents. For me, there's a strategy from day one. And that strategy is something that I try to stay consistent throughout the process. And I involve the client in the strategy. And we talk about the possible outcomes with employing one strategy versus the next strategy. The same way the CEO of a business, when they have the bet the farm litigation for their business, will sit down with their lawyer and talk strategy and be involved in the divorce the entire time. And one of the things that I think helps bring success to my clients is they know I'm willing to take the case all the way through the trial. I'm not afraid of the work involved in the trial. I'm not afraid of the attention the trial needs. You need to know that we're going to take it all the way. And many times the opposing attorney doesn't want to do the work and doesn't
Mhm.
want to spend the time to take it all the way. And that's very advantageous to my clients because the people who I work with and against know that I take this very seriously. And if they are going to take unreasonable positions, then the case is going to end in a decision in my client's favor.
Yeah. Well, absolutely. And here's what I want to mention or ask, I guess. So, one of the things that I've seen over the last probably 5 to 10 years is that there's been this shift between people really wanting to go in the direction of the alternative dispute resolution options, right? And I can see the value if it makes sense for that particular situation. But I almost feel like the pendulum has swung in the totally opposite direction. And we've got a lot of people who are doing mediation who, quite frankly, shouldn't probably be doing it because it's not a good fit. And I'm speaking on behalf of my clients who find themselves in these situations where they're doing mediation because they don't want to rock the boat. And there's this differential of in power, and they don't feel like they're being advocated for. They don't feel like they're being heard. And of course, that's not coming from me, right? It's more on the legal side. But my job is to be able to help level the playing field. The other piece of that, and you alluded to that, and I was taking some notes because you hit on a couple really important key things, Brad. And that is also that at the end of the day, the women that I'm working with often feel like they don't have a lot of options. There isn't that strategy. I mean, I can't say enough about strategy. There's so many times when I'm trying to help my clients and I'll say, okay, we need to have a conversation with the attorney. What is their legal strategy that then I can help on the financial side partner together, right? And make sure that we're all in alignment. And ultimately, at the end of the day, the clients win when their team is working together on their behalf. Along those lines, though, the mediation piece of it, one of the things that I think is happening, and again, this is a disruptive statement, so I will say that ahead of time. I think a lot of the attorneys that end up doing mediation are doing mediation because they personally are getting burnt out. It's not necessarily because they believe that it's absolutely the best. They think it's the best because they're now offering it, right?
Yeah.
But ultimately, that's what I've seen. It's like, oh, we were doing litigation and now we're doing mediation. They're not doing mediation because they are good at it and they're great at negotiating or they're great at communicating or they're great at whatever. They're doing it because out of self-preservation because they're burnt out and they don't know what else to do.
So I have a lot to respond to there. The first thing I wanted to acknowledge is you put your finger on one of the biggest problems in mediation, which is the power balance. Okay. Court systems, while none are perfect, generally speaking, apply the rules to everybody. And if one person's not playing by the rules, they have the ability to force them to play by the rules. Mediators don't have that tool. You made a statement. A lot of women feel like they're in mediation because they have no other options. The fact that they feel they have no other options is exactly why they shouldn't be in mediation. Okay. Because if there is one person who is not going to play by the rules, who is the more domineering one, now there are some great mediators who can help with that situation. I don't want to say that there aren't, but if the mediator isn't able to kind of equalize that situation through some crafty discussion because they have no contempt remedies, they have no enforcement remedies, then that person is in a bad situation. And all it is a repeat of the very power dynamic that they felt helpless in during the marriage. So I wanted to say that you are absolutely correct about that. And before anybody pursues alternative dispute resolution, someone has to do an analysis of whether
Mm-hmm.
the power dynamic is appropriate for it. Absolutely correct. The second thing that you said that I want to supplement is you said that it was disruptive. I think it was letting people off easy by saying they're burnt out when they're going to mediation. I think there's one more specific reason and a much harsher reason, which is they don't want the conflict in court. They don't want to do all the prep work that you need to do in court. You go to mediation, you pick up a file, you talk some numbers, they say X, you say Y, find a way in the middle. That's not a lot of work. That's not a lot of skill, and it's not putting you to your work. You don't have to perform in front of a judge and do a great job. So you say it's out of burnt out. I'd say it's out of a lack of a desire to work hard. The second piece of it, though, I think people are doing it is because they think they should, because
Mm-hmm.
people are afraid to say to a client, mediation is not for you. Because in a way, they think the client is looking at them like they want to take their money. But the problem with mediation, if it isn't a good, viable option, it's just an added layer of cost.
That's right.
Okay. And I can't tell you how many people have come to me from the mediative process and said, this is going on and I just don't feel comfortable with this. And after 5 questions I asked them, I realized this process is not for you. And the fact is, I have one client that I'm working with right now that where we are in the negotiations after about 6 months of court battle is in such a far better position than they were considering resolving the case in mediation. And I mean by a factor of two. But everybody in the process was just like, come on, you were here at one place, he was here. Let's find something in the middle and move on with our lives. And it was not good for this client. The dynamic wasn't good for the client. The process wasn't good for the client. The communication wasn't good for the client. And that's why whether or not to do mediation has to be a decision and a strategic decision made.
Absolutely. Absolutely. I love the energy that you bring because I think at the end of the day, this is the advocacy component that I think is now missing in the family law space, right? And I'm not saying like fight, but yet at the same time, I'm saying advocate, right? Because I think at the end of the day, our clients deserve for us to advocate for them and be strategic and have a game plan. So at the end of the day, and I'm feeling those questions too, the people that come out of mediation and they're like, Rhonda, we're a year, 2 years into this. We're not any further along. I don't even know what's going on. I don't have access to the documents. I still think he's potentially hiding money, et cetera, et cetera, et cetera. And so I am curious if you would be open to sharing a couple of the questions, because you said you asked your client, right? Hey, listen, let me ask you 5 questions, and I'm going to be able to determine if mediation is a good fit for you or not. Give us a sample of what some of those questions would be.
Number one, tell me about your spouse's financial situation. What do you know? The more, if they say, oh, well, we share this, we had this, I know he earns this, I know his business was this. I say, okay, this person is informed about the finances enough to be able to make an educated decision. Because if they don't know those things, how can you make a decision of what's what? The next thing I talk about is tell me about your communication style with your husband. Well, he never tells me anything. Anytime I ask him a question, he makes me feel bad, so on and so forth. Now we have another information gap. You can't make an informed decision in order to settle a divorce if there's an information gap. I ask about domestic violence, and I actually am educated on domestic violence and know that it's not about black eyes and broken bones or else everybody has it. I listen to them and not what they say, but more of a holistic approach, even about how they say it. There's a lot of people who come to me and say, my husband's abusive to me. Okay. And then you ask them why. And then what they say isn't a pattern of abuse, it's a pattern of disagreement. It's a pattern of one wants something, the other one didn't give it. And then there's people who say, there's no abuse in my relationship. And after 5 minutes, I say, you're one of the most abused people I've ever met because they're afraid and they're timid. And when I have someone who comes to me, and maybe not a specific answer to a question, but I can see that they are terrified of their spouse. And I can see that some of the things their spouse would say to them, like, you're not a good mother. Like a lot of people come, he's going to take away my children. Well, he works 23 out of 24 hours. You're a stay at home mom. But they really believe it. Why? Because
Mm-hmm.
they've been told and put
That's
down
right.
and insulted for so long
Mm-hmm.
that it becomes part of their psyche. Well, that person isn't fit for mediation either. And the other thing is that mediation is going to require trust. When you
Mm-hmm.
have a relationship that there is simply no trust, and that no matter what the other side says, they can't be trusted, and maybe deservedly so, that's also not a situation for mediation. Okay, because mediation, you don't turn over every stone to find every penny. At some point, you're going to say, this is pretty close enough. And there are
Mm-hmm.
people who simply will never trust their spouse, that they will come with even close to honest a situation. And that's a case that you need full discovery. You need document production, someone to, they need a financial advisor at times or a forensic accountant to come in and value things and look at things. And in those situations, mediation really isn't meant for that type of really close review of what exists
Mm-hmm.
between the parties.
Yeah, absolutely. And one of the things I was thinking of while you were talking, and I know that I share this with my clients, is I say, listen, when you're considering which path you want to go down, you have to be brutally honest with yourself. Because if you have 10, 20, 30 years of this power imbalance or bad communication or lack of transparency, going through this process is not suddenly now going to magically fix that. It's going to be that and probably worse. And I think one of the areas, Brett, that I see the biggest challenge in for my clients is discovery. There's a lack of accountability, there's a lack of transparency. One of the things that you talked about is gaps. And so, as part of my bridge method, is something that I take all of my clients through. And it's just a nice framework when people are feeling like they're swirling, they need to be grounded, they need to figure out what am I doing next, right? Especially when we're maybe in these balls within the legal portion of the case where it's like, what else can I be doing, Rhonda? Well, guess what? There are things we can be doing. We can be working on your budget. We can be making sure that we've got your documents organized so that when the attorney is looking at that information, it's super simple and they're not wasting their time opening up files that aren't labeled and,
Right.
all of those things. But then we also get to the point where we're identifying gaps, and that's actually part of my bridge method. So we breathe and build the team, making sure all the things we've talked about, you've got the right process, the right people. And then we move on to reviewing the financials. So gathering and organizing documents, budgeting, things like that. Practical and yet super important. And then we identify the gaps. And you talked specifically about this, identifying gaps in transparency, gaps in information, gaps in income, gaps in expertise. right? And so there's where we're identifying those gaps and saying, hey, listen, what else do we need to do here to help close that financial gap for you? And then we're dialing in the data. That's looking at property division and support. But all of the things that we're doing, right, are building upon that. And then once we get toward the end, it's guide to finish strong. How are we making sure that we're finishing this case in the strongest way possible? And one of the things I often do is review the financial aspect of the final agreement to make sure that from my vantage point and my trained eye, that if there is anything else that's missing, we make sure that we button that up. And then once the process is over, we can now exhale, right? We've got this, okay, what's expectant for this next chapter, and we can get those loose ends wrapped up and then move forward. And then we, of course, start that process over with somebody else, with their next person. But I think at the end of the day, there's so many things that you're touching on that have been a lot of the areas of my biggest frustration in doing this work. So glad, because I feel like what you're sharing is really resonating not only with me, but me on behalf of my clients and all of our listeners that are listening to this podcast. Okay, so we ask these questions. They decide that, either they're going to go the litigation route, the mediation route, etc. Let's talk just really briefly about some of the other things that may be playing into this case. Specifically, right, I know the reason that I reached out to you was this whole concept of lack of affection, right? This affection alienation. Maybe this is a new concept for some of our listeners, but let's talk about that. And if you're not in a state that this applies to, let's try to find some ways that we can just help them kind of maybe reframe what's going on.
So, first of all, I want to go back to something you said because you talked about the many ways you help your clients. And I bet there's one that you failed to mention, but is probably a big part of it because I know it's a big part of the end case for my clients, which is when they get their final offer of settlement, particularly the less money party, the recipient of this, they want to know, am I going to be okay going forward?
That's right.
And I
That's
bet
right.
you help them tremendously in that. And that is such a big part
Yes.
of it. And it's something that I have to say, matrimonial counsel is not qualified to do. And you have to bring in someone and either refer them out or bring in someone you work with to say, okay, here's what it looks like. And I have seen the work of, the financial advisors, the financial planners of, okay, here's what you got. You can afford this type of house. Here's what your spending will look like. And here's how long the money will last. And that is a big part of kind of getting
Yeah.
someone comfortable with the settlement that they put in. But back to your question about alienation of affection, which is really a tort in a number of states, but now only about 5 still have it. North Carolina being probably the most well-known and prominent because they've had some massive cases coming out of it, is this concept, and it was I think 46 states had statutes, most of them have done away with it, was this concept that if a third party interferes with your happy marriage. So the elements of this tort was you are married, you're happily married, someone comes in and interferes with that happiness, and the person did that maliciously, that would be this alienation of affection. Now, what a lot of people don't know is they think, oh, it was the person that was cheating, my husband or wife was cheating on me with. This didn't have to be someone where there was some sort of affair or amorous situation. It could be a therapist who advised you,
Mm,
don't stay with that person. It could be one of your friends was jealous that you're not going out with him or her as much. And they say, oh, this is a bad person. And I think this really opened up Pandora's box. And there was a time, and it really happened, I would say over the last 20, 25 years, where a judgment decision was made by states. And there were other aspects like not having fault. You used to have to prove fault in states, including about 10 years ago, New York. You'd have to prove adultery to be able to divorce someone or cruel treatment. The legislatures and the public opinion came about to say, we don't want to know what happens in the personal relationships between two people. And I relate that back to your question because when you're going through a divorce, everything that's happened to you seems like the most relevant thing that's ever happened. You talk to your friends, you talk to your coworkers, you talk to your family, you want to go to court and talk to them how you've been victimized. But at the end of the day, most people don't want to hear about it. I mean, yes, your family, they want to help counsel you through, but everybody's concern is just that you get through this happy and healthy and being able to take care of your kids and be able to afford it. The problems that you've had in your relationship, most people don't care about, and you have to have that perspective. in your life that you will never get satisfaction from a court. You'll get a schedule with your children. You'll get a certain amount of money, or you'll have to pay a certain amount of money, but you're never going to get a judgment that the other person was a horrible spouse to you. All right. And so when you have to put your situation before a court, you have to do it. When you have to explain the history of your marriage and you have to protect yourself or your children from abuse, you have to put those things through. But really, there's been a consensus in the country that otherwise people don't want to hear about your personal problems that you've had in your relationship or relationships with someone else.
Yeah, absolutely. And so for the states that have the alienation of affection, it ends up being what, a civil lawsuit as it relates to that, that then
Correct.
is it running simultaneously with potentially the divorce process?
It would run simultaneously with the divorce. There's also another concept that some of the states have called criminal conversion. And even though it's criminal, it has nothing to do with crimes. That is the act of someone sleeping with your spouse. Okay. And that kind of goes hand in hand with alienation of affection. A lot of people think alienation and affection, the tort, is really the criminal conversion. But the criminal conversion is the sexual act, where alienation of affection, like I said, doesn't have to be sexual in nature at all. You just have to basically break up a happy home. It could be the mother-in-law. I mean, that's how broad it could be. But it is a tort that happens separately. And the reason it usually happens separately is the person you're suing isn't your spouse. It's the person who alienated the affection between you, which could be their paramour. But again, it could be some other source in their life, relative, friend, and what have you, that really broke up your home.
Yeah, that's really interesting. And so in the article that was written in People magazine where you were quoted, how did social media play into this whole thing?
Well, I mean, it played a massive role, in my opinion, in that case. And, social media is playing a massive role in all types of family law litigation. But to answer that specific question, her name was Miss Kennard, who had the affair with her friend, Miss Montague's husband. Mr. Montague was her business manager of sorts. And she, about this affair, spoke about this affair, bragged about this affair publicly. And as I said to you, people might not want to know what's happening in another person's bedroom. But when someone takes that and blasts it to, I think she had 3 million followers, and people can understand how devastating that would be, that takes it to a whole new level. Now you've taken it out of the privacy arena and broadcast it to the world. And now there's going to be some consequences for that. And so I would say that social media was the linchpin of this decision, a $1.75 million verdict. And understand that North Carolina has had a $30 million verdict. There was a $3 million settlement involving Richard Gunn, Rick Gunn, I think was his name. He was a state senator there who had an affair with a staffer who was married. More public this becomes, and in Kennard case, she made it public. I think the more punitive a jury's going to be with respect to their award, and the less sympathetic they're going to be to, hey, the heart wants what it wants. People can live with that, but people can't live with you bragging about it on social media, because people can feel how horrific that would be. They have children. All right. Nowadays you can find anything anybody's ever posted on the internet. And so this information is now out there. And I think even less about the loss of a loved one and more about humiliation.
Yeah. And do they also see it obviously as reputation management, right?
I mean, I wasn't the jury. I can't say exactly what the jury saw, but this wasn't such an open and shut case, because you have to show the strength of the marriage. In that case, Mr. Montague had already had an affair. So there was some cracks in the foundation, but
Mhm.
that part wasn't really what carried the day. What carried the day, I believe, was the very public manner in which Miss Kennard bragged about this and humiliated her friend. And I believe that's where the
Mhm.
jury's attention was. I don't know without that this was a really strong case.
Yeah, it's so interesting. So share with us the five states that actually acknowledge the alienation of affection.
North Carolina, New Mexico, South Dakota, Utah, and Hawaii. And Mississippi may also, maybe six actually. But this is an ever changing thing. Even North Carolina has submitted multiple bills to try to abolish it. It's never passed. They've limited it somewhat because now it used to be that you could bring the claim anytime. Now you can only bring alienation of affection claims before parties separate.
Mm.
Okay, so anything that happens after parties separate is no longer actionable. So they've limited it. But again, this is part of a movement that you don't need fault to get divorced. You don't need to examine what's happening between spouses and in personal relationships and drag them before the court. That there's really a movement away from that. Doesn't mean the pendulum can't swing, but that's generally where this country is going on these type of things.
Yeah, super fascinating. And I think at the end of the day, I mean, gosh, we've covered a lot of ground, right, in a really short period of time. And I'm so grateful because I love your energy. I love the knowledge that you bring to this situation. Talk to us a little bit about, as we're kind of landing the plane, what are your final kind of comments, thoughts, encouragement to our listeners?
So be an active participant in your divorce. You alluded to it in terms of what can the person do to be a part of their divorce. Number one, you hold your lawyer accountable. Don't be afraid to ask questions. They work for you, not the other way around. Okay. I always say in the lawyer client relationship, it has to be built on trust. The same way a doctor patient. If you're having shoulder problems and your doctor says it's the arch of your foot, you go buy the orthotics because you trust the doctor knows what they're doing. Sometimes your lawyer is going to tell you something that logically doesn't seem to make sense in the moment, but can you trust them that they have your long-term well-being at heart? And if you don't, then you have the wrong lawyer. And if your lawyer doesn't call you back, you have the wrong lawyer. If they're not responsive to your emails, you have the wrong lawyer. And I don't mean you text them 17 times and they only send you back 16 responses, but I mean they're really not being responsive
Mm-hmm.
to you.
Mm-hmm.
All right. This
Mm-hmm.
process shouldn't happen to you, it should happen with you. Okay. And so if that's not there, you have to find the right counsel in this process because even divorce lawyers should never represent themselves because it is too emotional. The two most important things in most people's lives are their children and their security, financial security. Both of those are being attacked in a divorce. So while you're going through it, you need a calm, intelligent, trustworthy advisor to guide you through this process. And the more advisors you can, the lawyer can help you with the legal side, but they're not a good therapist. Don't ask them to be that. Find a therapist. I think in this world, there are two types of people, those in therapy and those who need therapy. And if there's going to be complex financial
Mm-hmm.
decisions you need to make, that lawyer is not trained to make them. You need to have a financial advisor because you need to protect all aspects of your life, your mental well-being, your legal well-being, and your financial well-being. And there's not one person who does all three. And if there is, they're probably not good at any of them. So that's my advice. Don't be a victim to your divorce. Take control of it with the right people helping you do so.
Thank you for the work that you're doing with your clients. Thank you on behalf of our listeners. This was really insightful. And yeah, thank you so much for your time today.
Thank you for having me.